Appeals Court, now sitting in Boston within the Commonwealth. Draw near, give your attendance, so you shall be heard. God save the Commonwealth of Massachusetts. Court is open. Please be seated.
Good morning and welcome to the Appeals Court. I am Justice Meade. To my right is Justice Walsh, and to my left is Justice Smyth. We'll be the panel on 5 out of 6 cases today. If you haven't been here before, each side gets 15 minutes. If you have been here before, each side gets 15 minutes. We do not entertain rebuttal. We have read everything. My best advice is to get right to the point. So with that, I'll call our first case, 23P 978, Griffith versus members of the Bellingham Zoning Board of Appeals. Ms. Baptista.
Good morning, Your Honors. May it please the Court. My name is Dan Hill. I represent the plaintiffs, and with me today is Caitlin Baptista. I'm going to take 1 minute just to give the lay of the land of this case, and then I'll get to the legal issues. They're pretty narrow. There's 2 legal issues in this case.
Why don't we go to the legal issues? That's 1 minute less that we'd have to talk about the legal issues. We know the facts.
Sounds good. This whole case revolves around the defendant's proposed use of land in Franklin between the edge of a cul-de-sac and the town line, which is also the beginning of the project site, this 40B project site in Bellingham. There are 2 things you need to know about this appeal. First, the facts are undisputed. This case really revolves around 2 narrow questions of real estate law, which this court can review and should review de novo.
You don't have any issue, though, with the standard of review, which has been cited as far as mixed questions of fact and law?
Well, I disagree. I don't think there are any questions of fact. So I don't think this is a clearly erroneous standard. I think this is strictly a de novo standard of questions of law. There's been no serious contest of the facts in this case.
Well, I'll wait till you get to the argument to ask you those questions. Go ahead.
Sure. So as to the second issue, what's important to know is that there are viable ancillary claims. There is an appeal of a zoning permit. That was count 4, but there's 3 other claims, and they all stand on their own legs. These claims can and should have been adjudicated independently of the zoning appeal. On that second point, what has been presented to this court are 2 claims that do not include the appeal of the zoning permit. The claims are related to the 40B project, but are not related to the permit itself. The claims have to do with the access to the project through, again, the land in Franklin. And specifically, the claims are, 1, does the extension of the Sunken Meadow Road, this is a private road, require subdivision modification approval in the town of Franklin, and the assent of the plaintiffs, who are the 2 lot owners at the end of the cul-de-sac. And second, does the use of Sunken Meadow Road in Franklin violate the Franklin zoning bylaw? The land court judge conflated all of these claims as basically one coordinated attack on the zoning permit.
All right, so let's focus in on counts 1 and count 2. Count 2 is a land as use, which we'll pass for a moment. On count 1, the second amended complaint, I think it's Record Appendix 144 in Volume 6, talks about 2 alternative theories, one under 231A, Section 1, one under the 10 taxpayer. You agree 10 taxpayer, it's not ripe. You're not appealing that decision by the land court justice.
Correct.
So on the first issue, under 4181 O and W, correct, the judge made a mixed, I would suggest, finding of fact and ruling of law. One is that the plaintiffs in this instance weren't aggrieved parties, citing to the case law that talks about, while the statute doesn't have a definition of modification, it does say aggrieved parties must consent to any modification that goes before the before the planning board. And so whether or not the developer has to go before the planning board, once the judge finds that your clients are not aggrieved parties, how do you have standing? How are your plaintiffs, your clients, any different than anyone else in the Commonwealth who may believe that a developer needs to go to a planning board or get approval for a modification? That's my question that relates back to the finding of fact mixed with law that I'd like you to address.
Sure. So our position would be there were no issues of fact. The judge ruled that we didn't have standing but that was a legal determination based upon
But the aggrieved
facts.
party, right? So if you are an aggrieved party, you'd agree that you get the say. You have to consent to the modification.
Right.
And the judge found, not ruled, found that your clients were not aggrieved parties because traffic and lights and those types of nuisances doesn't equate under the case law to
Right.
being an aggrieved party for purposes of valuation of your property. So how is that not a finding that we review with quite a bit of deference?
So the issue under Section 81W is, are the lot owners affected, the magic word is affected by the modification? And the judge held, as you said, that our clients or the plaintiffs are not affected enough to have their consent. And our case is materially distinguishable from the case that the judge cited, which was Patel. In Patel, those plaintiffs, their aggrievement was simply traffic and noise and nuisance. In this case, my clients, the plaintiffs, own the land. This is a private road, so they actually own until the center line of the road, including the unbuilt section from the edge of the cul-de-sac to the town line. So they actually own the fee of that road. They actually also have rights in part of the cul-de-sac. So the cul-de-sac is, the round end of the road. The portions that are rounded are actually on their land, on both of their land.
Your case is in a more difficult position for you to argue than Patel, and that this was an existing easement already. I mean, this is not something that didn't exist prior to the purchase of that lot of land.
Correct, but the easement, when the subdivision plan was approved in 1987, the road was not designed and built to accommodate 28 additional houses. And so the point here is that subdivision modification approval is needed so that the planning board can consider whether this road is adequate to serve 28 additional houses. The road only serves 12 houses under current conditions, and that's how it was approved in 1987.
Patel says changes to traffic, views, road width, it's my shorthand writing, doesn't affect the previously sold lots. How does that not impact your argument here?
So again, what's unique about this case is that the plaintiffs own the land, and they also are doubly burdened by easements. So they actually currently have a cul-de-sac on their property. When that road is extended, and I agree with you, it was contemplated because there was an unbuilt section. When the road was supposed to be extended, that cul-de-sac was supposed to go away, and they're supposed to get their land back and have it restored. Then they would only have one easement burden, which is the extension. But in this case, there's no plan and no intent by the developer to remove the cul-de-sac. So they're going to be doubly burdened by both the cul-de-sac on their property and the extension. And furthermore, that cul-de-sac doesn't have any sidewalks. So where they're located, they don't.
How can I evaluate what the intent of the developer is whether he's going to rip up the basketball court in front of somebody's home and stay true? I mean, isn't that for the purpose of another potential lawsuit of a claim that this agreement was to get rid of the cul-de-sac in lieu of building this easement in road to Bellingham?
Well, it's in the record that the developer testified at trial that he's not going to do it. So it's in the record that the cul-de-sac is not going to be removed. There was no condition that it be removed, and the Franklin Planning Board hasn't even reviewed this because the applicant hasn't gone before the Franklin Planning Board. It's important that my clients are not trying to stop the project. This has to do with process, that there hasn't been any review of any of this in Franklin. And the applicant is saying they don't need to do that. And the land court judge, ironically, did say, yeah, this has to go to Franklin, but the land court judge didn't actually incorporate that into the judgment. So really one of the main issues, the reason why we're here today, is to correct the judgment so that what the land court judge said was correct, that Franklin Planning Board approval is required, but for some reason he didn't put that in the judgment and said he dismissed count one.
I read with interest your motion to amend, your motion for clarification, and interesting, your argument on one hand is the land court was right. They just should have allowed count one, right? But on the other hand, don't remand it back to that land court judge.
Well, a remand doesn't, in our view, make sense because it's not necessary. The Franklin Planning Board can do what it needs to do without having a judge supervise it. The applicant has to file something to the planning board. Once that's filed with the planning board can take testimony, can hear from abutters, it can hear from the developer, and make a decision. If the developer is not happy with what the Franklin Planning Board does, the developer has the right to appeal it, just as my clients have the right to appeal it. So a remand, this is a very unusual proposal. It doesn't feel like it's necessary, and it feels like it's sort of like paternalistic, that we need to have a judge review this. It's completely unnecessary. Franklin hasn't even had a chance to weigh in on the modification of the subdivision.
I just want to make sure I'm clear with your argument. You don't disagree that the second piece, the 10 taxpayer kind of vehicle, isn't right, since no action was before the Town of Franklin Planning Board.
Oh, that's correct, and that was only added to the complaint after a motion session with Judge Rubin in the Land Court, where it was suggested that the DJ count was not sufficient, that we had to have a 10. We didn't agree with that, but we did it just simply because it was expedient to move the case along. So we have no problem with the dismissal of that count. We think we have a viable alternative count under 231A.
And I know that there are two other panel
No,
members.
go
I
ahead.
apologize for this, but I find this case to be very interesting.
Sure.
So sorry. Could you get to the land as use argument and what you think is your strongest argument of why the judge erred?
Access is use?
Yes.
Sure. So this is Chapter 240, Section 14A, and the Land Court judge dismissed this on standing grounds. First, the judge concluded that there is no separate DJ claim when you're appealing a 40B permit. And this goes back to my overall argument here in this appeal, is that there are viable ancillary claims. Just because you have a zoning permit appeal doesn't mean you don't have the right to bring other claims that are related to the project, as long as they're separate. And the distinction here, again, this is more like the cases in Sir versus Dighton and Picard, appeals court and SJC cases we've cited in our briefs, where there was a permit appeal, but the plaintiffs also had distinct other private causes of action. And that's the case here. These cases are distinct because these issues could not have been resolved in the underlying permit process in Bellingham. The Bellingham Zoning Board had no authority to make any kind of decision on subdivision modification in Franklin, or count 2, access is used to determine whether the access driveway in Franklin violated Franklin zoning. Bellingham Zoning Board doesn't have jurisdiction over those issues. So these issues are properly before the Land Court and now this court. Now the issue, again, is only standing. The Land Court judge didn't get to the merits of our argument, but basically held that there's essentially a 40B exception to the access as use doctrine. The access as use doctrine has been in existence since the mid-1970s, and just simply says that if you have a project in one town, that use has to be allowed where your access driveway is located in the other town. There's actually several cases that speak to this issue. There's no justification for any kind of exception to this doctrine with 40B. And I wanted to just briefly address the applicant's rationale. The developer has made the suggestion that this is analogous to the Tracer Lane project, which is a solar farm. And in that case, the city of Waltham denied the applicant, the solar farm developer's access through Waltham to get to a solar project in Lexington. The SJC said that that's not tenable. Waltham can't do that because Waltham was very restrictive when it came to solar farms. It only allowed them in 1 or 2% of the city. This case is different because this developer has never gone to Franklin and asked for permission to provide the access driveway in Franklin. Further, if it did do that, the Franklin Planning Board or Zoning Board would deny it because the use of the access driveway in Franklin would not be allowed for the project in Bellingham. It's simply not in the cards. There's a very big distinction then between this case and that Tracer Lane case. Frankly, the town of Franklin actually has met its 10% affordable housing obligations under Chapter 40B, and so therefore it may not even get approved in Franklin. So I think that's all a question for another day. Well, all we're here today is asking for this court to remand to the Land Court to have that issue adjudicated, that we actually do have standing in this case. It was a mistake for the Land Court judge to say we have to prove standing, where we're asking for a declaration of the applicability of a zoning bylaw on our land, not someone else's land. Now, we agree that if we were asking for that on someone else's land, there would be a standing requirement. But again, the land at issue is land that my clients own. They own the fee of that extension from the cul-de-sac to the town line. And so there shouldn't have been this standing burden to my clients.
Thank you.
Thank you.
Mr. Brake.
Thank you, Your Honor. May it please the Court, my name is Stephen Brake, and along with my colleague Mary L. Smyth, we represent Mr. Gately, the trustee of Hidden Meadows Trust in this case. While I've sat here, rewritten my argument in my head a little bit to respond to Mr. Hill, and in particular on this question of the land court judge having, in his view, essentially decided the 40A Section 17 case, and that somehow the independent claims, as he refers to them, didn't get addressed fully and fairly. And I think that is, I would submit to you that that is per se not what that decision does. On the contrary, the land court judge takes each of those, and in fact, I would submit in a very confused situation after the evidence of trial, did a masterful job actually of separating out each of the claims as asserted in the 4 counts and addressing each of them on the merits in the sense of applying the substantive applicable law. And the first of them really is, he obviously begins the decision with a fairly lengthy discussion of standing, the traditional analysis, 40A Section 17 standing, and then he applies it as it is meant to be applied in a 40B context to the Standerwick case, because there are narrower interests that you have to assert. 40B overrides the traditional zoning concerns such as traffic, noise, and density and such. And he finds unequivocally that these plaintiffs, first we rebutted the abutters' presumption. Second, they came forward with nothing but speculative evidence. And he's fairly strident about the lack of credibility on their part on that analysis. So he dismisses the 40A 17 case. And what the plaintiff's real contention is next is that you go to count 4, I think it is, and they say that their Chapter 240, Section 14A claim somehow allows them to bring up the very same issues challenging the permit through the access is use doctrine. What they're really saying is this permit is invalid because while it is a project itself in Bellingham, you have access to a public way in Franklin. Therefore, access is use applies. And the Franklin zoning bylaw does not allow for a 40B project of this type. And if I remember correctly, the zoning imperfection under Franklin zoning is that this is one large lot with common ownership of the underlying land. And that supposedly, Franklin would not allow that. Therefore, this project fails. And when you look at that issue as it's presented directly by the plaintiffs, that is not allowed under Chapter 240, Section 14A. And the Whitensville retirement case, in the final 2 pages, subject matter jurisdiction, directly addresses it. And the language is absolutely clear. You read the language of the statute itself, and it was expanded a little bit in 1959 by the SJC to say it isn't just the landowner's own case, own land, sorry. It can also be the adjoining land if it's going to affect them. But basically, you go and you seek a declaration as to how the zoning bylaw in the town affects your property. That's not what they're doing. They are challenging a zoning permit, and that is expressly precluded by the Whitensville case. But what's interesting is precluded for what I would submit is a very interesting reason that goes somewhat unexpressed. But the whole point of Chapter 40A-17, as applies, of course, to 40B, the point of that statute is for the quick resolution, there's a 20-day period to file those cases. They're supposed to be resolved quickly. And what's more, Chapter 40B has a standing, the Standerwick case narrows standing very much for a Chapter 40B case. And under the conception that Mr. Hill is advancing, none of that would matter. I could lose my 40A case, as they did here, for a 40B permit. And I could turn around, recast it, challenging a permit in violation of Whitensville, but in addition, recast it as a claim for 14A. And essentially what you would do is you would revive claims challenging zoning permits no matter the age of them. And in fact, that's what happens in Whitensville Whitensville is the permit was issued in 1975. The case gets litigated in the 1980s. So they're essentially saying, I want to know what that 1975 special permit means. Does it preclude this? Does it allow it or preclude it? It's actually what they're trying to do here. So, not to belabor it unduly, but 240, Section 14A, does not provide, as a matter of law, an end run around the fact that they were precluded because they couldn't prove standing under 40B to challenge the permit.
I understand your argument, but to counter, I think a reasonable argument and one that has some force is the plaintiff citing to both appellate court decisions and the SJC that says zoning challenges aren't the exclusive remedy, that there are other common law theories in which they can succeed.
I totally agree with that, Your Honor. It just so happens, I totally agree with that, and the judge gently chides me for my emphasis on 40A-17 at the beginning of it, and I think we misunderstood one another because as far as the easement rights that they claimed, that he disposed of those claims factually, and as far as the subdivision control law, right, those remedies exist independently. However, I would submit the one thing you cannot do is, having failed to properly bring a 40A-17 case challenging 40B or 40A project for that matter, you cannot recast your claim as a 240 Section 14A claim. And basically, it comes down to the fact, I think Whitensville's been followed a number of times, but that discussion at the end of the final 2 pages of that case, I think disposes of that particular version of an alternative relief. The court, I submit to you, as a factual matter, dealt with all the myriad of easement-type claims that were made, which really brings us, I think, to what he called the only formidable challenge to the project, which is the subdivision control law, how that applies here. And basically it comes down, I would submit, the core of their assertion is that 2 things needed to happen. First, under Patel, and they claim Patel supports them, which I'll address in a second because I don't think it does, quite the opposite. They're suggesting that the language, I think it's Section 81W, about affecting the property means that their clients had to consent to this project, basically, and to the alteration in the roadway, so-called alteration. In truth, and the case law supports this, what actually is happening is the existing easement is being paved over. Now, I understand the judges said you have to go talk to Franklin about that. I'll address that in a second. Independently, first question is, do the plaintiffs have a right to consent to this because it, quote, affects their property? And I would submit to you, when you read Patel carefully, and I went back and reread it a couple of times yesterday, Patel says the exact opposite. What the Patel case does is it says, and in that case what happened is there was a subdivision with a turnaround, and the developer decided he wanted to change the project, so he went and filed to change it, extending the turnaround to a through road. And the result was it was increased traffic, and as the plaintiffs said quite candidly, I think in that case, it's more desirable to live next to an underdeveloped wooded area than it is to have houses next to you. And therefore, they said, because of those 2 effects, this affects our property within the meaning of the statute. And the court, this court, Justice Cass, looked at it carefully, looked at the legislative history, said, no, this is what this means. And the statute says, by its very terms, you know, does it materially affect the title of bona fide of properties? And they outline the kind of things that are covered. If you change the shape of the lot, you put extra easements over the lot, you do this, that, and the other, you know, that goes to title, that affects it. And this situation, where the traffic's going to be different, where the configuration of all the things that they claimed was their source of harm, that doesn't rise to it. Patel, I mean, you know, I was almost so flabbergasted when I read it again, as I'd forgotten how clear it was. The plaintiffs do not have the right to consent to this. Now, their last refuge on this is they bring up this notion of supposedly double easements and whatnot. But when you parse that through, they're essentially complaining, as you heard today, that there's no clear plan for what happens when the turnaround, when the road is extended to the curved bit that impinges on their property, which the original plan does say 7 and 12, the 2 lots that have a turnaround on it. Well, the reality is that Section 81Q of the statute says when a roadway is extended, that the temporary turnaround easement disappears. I forget the exact phraseology, but it goes away. So the reality is, someone, and if it's a debate about who's going to pay for the jackhammer to go out and get rid of the extra little bit of the property, of the pavement, I'm sorry, then perhaps that's a debate. Perhaps the town of Franklin, when we go back to them, if you were to take my proposition up about remanding it, maybe they would address that. But the point is the easement is gone. Then the turnaround easement is gone. Our easement, so to speak, pre-exists and goes to the town line. So this whole notion of some sort of double easement arising out of their rights under the derelict fee statute and such is not a basis to do anything here, quite frankly. They are back under Patel asserting that the increased traffic and the lack of desirability of having, I think it's 28 new houses built on this property, gives them a reason that it affects them, and it doesn't. Which leads me really to the final sort of individual substantive question, it seems to me, is the judge's conclusion that Franklin needs to be consulted. And it seems to me, I don't actually know that he really comes out and says in a clear declarative sentence that it constitutes a modification. His ruling is tantamount to that in some fashion, so we've not challenged that or appealed it. We've been, well, you saw in the briefs what I suggested was that this judge has a lot of knowledge about this site now, and I would submit to you the 10 taxpayer statute is not ripe. The plaintiff's position, while I think they agreed with Your Honor first thing today, their position really saying that count one should be reversed is really tantamount to saying that the 10 taxpayer case you should rule in their favor on that now. And axiomatically, it seems to me that's not true. If you read the statute, it talks of action or inaction by a board, so it's not right. That said, what clearly needs to happen under the judge's decision is my client needs to actually file something with Franklin. I would note, if I may.
Let me interrupt for a moment. As a former trial court justice, can you point anywhere where there is a case or a statute or anything that gives an appellate court the authority to create personal jurisdiction for one particular judge to handle the remaining parts of a case?
Well, I do think so, Your Honor, and I forget that.
Cite to me a case?
Well, I believe that it would come within this, essentially, the supervisory and equitable powers of the court for a very specific reason, which is in the land court and in zoning cases generally in the Commonwealth, over the rather extended period in which I've handled them at this point, I would say it is a very common practice for land court judges.
Didn't disagree that if a land court justice put in lots of effort and knows a case backwards and forwards and says to his or her colleagues, I'll pick this case up when it comes back again for the 50th appeal because I have all of this underlying knowledge, that probably under some sort of general authority, no one could quibble. I'm wondering what kind of authority an appellate court
Candidly,
have in forcing.
No, I candidly conceived of it as an extension of the same doctrine. And the reason I do is we heard today that the clients only want to vindicate their procedural rights, they're not really opposing the project. That's, I submit, not the case. And this is a classic attempt to impose long-term delay in connection with the 40B project. It fits the profile. And the Commonwealth does have a strong policy, as we all know, and I don't regurgitate it at length, but I submit here that the purposes of the statute will be best served by having a prompt process. I understand we're subject to a 10 taxpayer suit down the line. If I disagreed with the judge, I should have cross-appealed, and we didn't. I understand that, but I do believe that waiting for an extended period for a resolution of what is, as he delineates quite, he's got his read. He says you got to be mindful of 40B. He tells them what to do, which is one of the things they objected to. I think justice would be served under 40B by doing it this way. And, but I understand your Honor's point. That, is there a statute saying an appeals court can do it exactly this way? No, but it seems to me it's a supervisory matter analogous to the land court doing it itself. One last point, if I may. Tracer Lane, interestingly enough, Tracer Lane was the access is use case, was a 240 Section 14A case, where ahead of time they went and they said, we want to understand if we can do this. And it's an access is use case. So we drew the analogy between the Dover Amendment and our case. Thank you, Your Honor. Appreciate it.
Thank you. Thank you all. We'll take it under advisement. The next case is 23P456 TJR Services versus the Hutchinsons. Mr. Vaughter.
Good morning, Your Honors. My name is Tom Vaughter, and I represent William and Deanna Hutchinson in this appeal. The plaintiffs brought this complaint as not a bona fide purchaser of a piece of property, that they relied completely and solely on the recorded documents, which they don't have any personal knowledge of, but they're saying, here's what's recorded in the registry, and that is sufficient. That's the basis of their complaint. The defendants have objected throughout, and when you look at the record, there is no place that the court was given, well, the court may have had an opportunity in the motions for summary judgment to rule as to whether it's a disputed or undisputed fact regarding the 2012 assignment, the only assignment, or the foreclosure deed, or any document, but he didn't. He limited it to saying undisputed fact that nothing to do with their complaint, that there is some securitization that he's going to rely on for a not recorded assignment. So, if in fact in his initial judgment or initial order denying cross motions for summary judgment, he said, I don't need to consider the only assignment that's been recorded at the registry. And there is no place in that decision that speaks at all about the foreclosure deed or the affidavit or any of the other documents that were recorded. So then we come to trial. And at trial, they came ready for bear. They said that they had all these documents, including all the recorded documents that they wanted to put in. They didn't put one of them in. They're not admitted. They're not before the court. The court is not able to make a decision based on, because certainly the defendant's position from all along is they can't prove their case. The fact that those documents exist do not allow them to prove their case. They have to show that the contents are valid, and they have done none of that. So when we end up at the end of the day, they have not shown that they even have standing to be in this court. I would add to that early on in the case, the defendants filed a third-party complaint against Tank Menace. Tank Menace was the entity that became record title holder after the foreclosure deed. It's interesting to note that in their complaint they don't mention that. We file a motion to bring them in. And when we file that motion, Tank Menace comes in and says, we don't have anything to do with this. We don't have any interest in this. And goes on, actually says, as in the addendum, page 6, noted by the judge says, Tank Menace concedes that it has no interest in the property and agrees that the court may declare at the conclusion of this case the Hutchinson's first claim, our declaratory judgment claim. And if you look at our claim and you look at what we put in that, it includes that the foreclosure deed was null and void, and that Tank Mendes didn't receive anything, and they have agreed to that. That's what the court has ordered. So now at the end, when you look at the judgment says, yes, we're granting the third-party complaint in favor of the defendants with respect to this issue of the Tank Mendes. And then a little further down says, oh, by the way, we're finding that that deed is valid. The deed in the Tank Mendes is valid. How can the deed be valid in the Tank Mendes if Tank Mendes comes in and says, we don't have any interest in it, and the third-party complaint declaratory judgment sets out facts?
They had interest until they sold it, no?
What's that?
Tank Mendes had interest until they transferred it to TJR, correct?
That's not the way. I don't believe that if you look at our third-party complaint, which says that the foreclosure deed was not valid and that Tank Mendes didn't have an interest, and Tank Mendes' only interest, again, as a non-bona fide purchaser, was it got some kind of release deed, they got something. But what did they get? And is that where it came into TJR? I agree that that's what the record title says, but that's not in the record. What's in the record is our complaint, our third-party complaint. They're conceding that they don't have an interest and permitting the court to enter a judgment on behalf of the declaratory judgment action that we brought.
But do you agree that this trial wasn't held in a vacuum, right? So procedurally, there were cross motions for summary judgment. The judge made certain findings of fact in the motions for summary judgment, which narrowed the issues for trial really to whether or not it appears whether U.S. Bank at the time of the foreclosure held title, correct? And then secondly, whether or not the piece about the acceleration clause. But earlier on in your presentation, you had said, well, this wasn't proved and this wasn't proved at trial, et cetera, et cetera. It seems to me that procedurally, the trial became very narrow as to those specific issues. At the time of the foreclosure, was U.S. Bank as the trustee for the OA3 trust?
What I would argue on behalf is, first, the court bifurcated the case, and bifurcated it, and that's on addendum 14, bifurcates the case and directs the party complete discovery of the issues of the validity of the 2012 assignment and the propriety of the foreclosure on defendant's title. So that's what the trial was about. We did not agree to the narrowing of the issues. We, in fact, you'll see it in that we had 24 issues that we thought ought to be tried at the trial. Now, it was narrow, but if you look at both of the denial of the motion for summary judgment, cross motions, and the amended order, there is no consideration of the assignment. There's no consideration of the foreclosure deed. There's no consideration of the affidavit. So that
So is your quarrel with, just so I understand, the judge's failure at trial to address all of these issues, or the judge's failure at the motion for summary judgment to address 22 other?
I don't know this is, well, so I have a problem with the judge coming up with a decision that he did, but it's really the plaintiff. The plaintiff had all of these documents that they could have attempted to get into the record. They have the assignment, they had all those documents. They actually showed up in court with 3 binders with 28 documents, and there's 2 agreed documents. There was the deed into my client, and there was the mortgage into my clients. And that was the only recorded documents that were allowed in at the trial, and there was only one other document that was not any of them that they had based their complaint on. So that I think that the case went off the rails, and but the plaintiff certainly had an obligation to try to show that they had standing. They haven't even been able to establish that they had standing because they didn't produce any documents. They didn't introduce them. The court didn't consider them.
Well, counsel, wasn't the court following proper procedure under 56D?
Well, I would say that.
I think the approach that.
If we go to the issue that the undisputed facts, the limited undisputed facts, the undisputed fact that he found that there was an unrecorded assignment.
Well, not that he found, you admitted to it, correct?
Well, but
Before
in order to have an assignment of legal title, you need to comply with the statute of frauds. There is no way that my clients knew whether there was one or wasn't. We answered, the question was, in the interrogatories, the question was, what are the bases that you don't think that we have good title? And so we listed 25 possible bases, and one of them was that it appeared that they may have been assigned. But they didn't prove that it was assigned. There is no proof. It's in fact stipulated that there was no assignment from Washington Mutual Bank out. So if there's no, so they're then forced to go into the assignment. But the one assignment that's in record is the only thing they have any knowledge about. But they don't. It's not before the court. It's not considered or decided. It's not part of the decision. And I'm not sure if I've answered your question, Justice, but it seems to me that it went off track, but that the burden is on the plaintiff to prove their case, and they didn't repeatedly. And throughout the process of summary judgment, repeatedly we moved to strike these documents, and we objected to the statement of fact. I agree that we agreed in there for purpose of the summary judgment only, we would agree that that something happened to that mortgage in February of 2007 and March of 2007. Something happened to it, but there's no proof of what happened to it. And to say that the court does not have to rely on the statute of frauds because my client, who, as this court well knows, cannot challenge the PSAs. They cannot challenge the pooling and service agreements. They can't challenge because they're not party to it. And if that's true, the plaintiff certainly can't. So we went way in a different place that had no expectation that we were necessarily going to go. But they still have the proof. So I think and there's nothing to suggest that securitization doesn't require proof of an assignment of a mortgage if you can rely on that someplace, and it's not here. And so if you say, well, we all know about the FDIC taking over Washington Mutual. There's nothing before this court, and there's no decisions before that court regarding that. They didn't try to put that into evidence again. So you could say, well, so how can a court take judicial notice of something that's not there? And they are clear that they're not bona fide purchasers because they said so. They actually filed a motion to amend their counterclaims in order to redact every place that bona fide purchaser appeared in their answer to the counterclaims. And in those answers to the counterclaims, repeatedly they said, if it's in the document speaks for itself. And if it's not the document, we don't have sufficient knowledge to affirm or not affirm because they just don't know. So one of the things is, from my perspective, is one of what's happening is that they were very cute in their complaint. They said one of the count 3 was a complaint under 240. They didn't say 240, 1 through 5 tri-title. They didn't say 6 through 10, which is quiet title. In both cases, the only way you get to bring that claim is if, in fact, you're in possession of the property, which they're not. But they put that in there, and then during the course of the litigation, they said repeatedly that, yes, this was quiet title. And one of the places that they say that, and proposed a request for admission with respect to the first motion for summary judgment that we brought regarding res judicata. And they said in response to number 50, where I said, you're not making a claim under quiet title. It says, plaintiff denies this allegation as the current complaint is, in part, an action to quiet title. So I think that the court So the count 3 should not have been ruled on. That should also go away. So all we're left with is a declaratory judgment that somehow they haven't proved their case and didn't attempt to prove their case, and certainly not over the objections of the defendants.
Mr. Vaughter,
Yes.
the res judicata claims that you made on the second floor or earlier this month, are they the same ones in this case?
There's the same case. So it's,
I know it's the same.
So it's different.
They only took the
It's
single.
different. So in that particular case, so in this case, we brought the res judicata claims based on the fact that there was a judgment out of the housing court in which the judge made particular findings. And those particular findings were based on the very facts that they brought this case on. The exact same facts that they put in their complaint was before the housing court. And the housing court made specific decisions, specific facts about the assignment, about the documents. And to suggest that somehow that a trust or not trust is de minimis.
Let me try to ask my question. If they're the same claims and they are indispensable to this case, do we need to wait for the SJC?
I don't think so. I think that the issue for the Supreme Court is whether.
No, I know what the issue is there, but
it's about use and occupancy.
If they're going to decide the same res judicata claims, does it make sense for us to do that before they do? And God knows why they didn't take both parts of this.
So it's a different res judicata claim because the plaintiffs are suggesting that the res judicata claim has to do with a land court case, not having to do with the housing court case. So they're saying that that's final, and therefore we can go back into housing court, back into the court that already has found that.
Right. Okay, I understand. Thank you very much.
If I'm
Ms.
over time, or is there any other questions?
No, your time is up.
All right, I'm good. Just
Ms. Traini.
Good morning, Your Honors. If it pleases the Court, my name is Rosemary Trainey, and together with Jeffrey Johnson, we represent TJR Services. Perhaps I wanted to respond to
Please go right ahead.
Judge Meade's question about the res judicata issue that was argued a couple of weeks ago. It is the same res judicata argument that was argued there. Their argument there is that the housing court judgment should be res judicata, and that's what they did argue in front of the Supreme Judicial Court. So I do think in some ways the SJC should probably have to decide that if they are going to decide anything on the res judicata issue as it related to that, because it all relates to the same thing. The res judicata,
it's indispensable.
Right. The res judicata argument was the same in both this case and in the case that the SJC heard a couple of weeks ago. With regard to the issues that are being raised this morning with respect to the trial and the summary judgment, throughout this case, there has been an argument advanced by the appellants that somehow we have to have personal knowledge of every document and every submission that's made, whether they're documents that are on record, documents that are on file at various agencies, and that unless there is this personal knowledge element, those documents cannot be used. In this case, what happened was we had a very lengthy summary judgment process in this case, where we submitted multiple documents, multiple versions of undisputed material facts. And at the end of the day, yes, Judge Vey did deny the summary judgment because he found that we didn't prove to his satisfaction that U.S. Bank was the trustee of the OA3 trust at the time of the foreclosure. Everything else, Judge Vey made determinations on. And he was very explicit in his summary judgment memorandum what he was finding, what he was taking judicial notice of. He made a determination on the de minimis nature of the trust versus no trust issue. He did under 56D all of those things and then said, okay, at the final trial conference, we have an issue that remains for trial because plaintiffs didn't prove to my satisfaction that U.S. Bank was the trustee of the trust. You have to prove that at trial. He then asked, are there any other issues that we need to address at trial that have not been addressed? The appellants spoke up at that point and said, yes, you have to address the paragraph 22 compliance issue. He said, okay, we're going to add that to the list of issues that need to be adjudicated at the trial.
Did you, when you, so you get, TJR gets the foreclosure deed, and you don't go to housing court and file a summary process action. Instead, you go to land court. Is that, did you have some question in the validity of the title?
Well, we knew from the fact that the Hutchinsons had filed 2 5B affidavits on record that they were challenging various issues with respect to the title. So we made the decision to go to the land court because there were clearly issues that they were raising in these 5B affidavits. Not that I can see that 5B affidavits are valid for raising the issues the way they raised them, but knowing that that information was in there, we took the position that the land court was the better place to go to address the title issues and not the housing court. So that's why we did what we did. But in any event, after the summary judgment hearing and after the trial conference, when we were putting together the trial books, the defendants raised a number of issues that they claimed were still not resolved. And that's why we brought with us documents. But the judge was very clear during the trial, before the trial started, and at every point along the way that he was not going to retry anything that he had already made a determination of in the summary judgment, that that was not what was before him, that he had used Rule 56D to narrow the issues, and that's what he was going to try. As a matter of fact, at the trial, the defendants raised the provisions of Section 35A and the notice under Section 35A. We argued that they should be precluded from arguing that, and Judge Vey allowed them to argue that as well. And so anywhere along the way, he made concessions to the extent that there could be any question as to whether something was resolved. But in this particular case, we had an agreed upon, we had agreed facts that were submitted, undisputed material facts. The Hutchinsons did not oppose the statement that their note and mortgage were in the OA3 trust at the time in or about 2007. So Judge Vey didn't disregard the 2012 assignment. What Judge Vey really did was he said, I don't have to address the 2012 assignment because these people aren't fighting about where the mortgage was and where the note was. They both agree that the note and the mortgage went into the OA3 trust sometime in 2007. That's not disputed. And at the summary judgment hearing, counsel for the Hutchinsons acknowledged that at trial, the evidence would be that it went into the OA3 trust. So that was in Judge Vey's mind. That was something that was decided. So the 2012 assignment's on record. The Hutchinsons provided no evidence that there's any other assignment on record. There is an assignment on record that is executed by Chase to the OA3 trust, and Chase was the purchaser from the FDIC as the receiver. And we cite in our brief a case by the name of Meade versus Deutsche Bank, which was a federal bankruptcy court case which went up to the First Circuit and was affirmed almost identical, where Chase recorded an assignment in 2010 to Deutsche Bank because, again, it was another securitized transfer, and the assignment had never been recorded, and they put it on. And the bankruptcy court judge found that, A, Chase had the authority to do it under its purchase agreement with the FDIC, and B, that to the extent it was curative, it was allowed. The assignment's on record because that's what the record title requires in Massachusetts. There was no dispute that it was already in the OA3 trust. The issues that are being raised now with respect to Tank Menace, with respect to the OA3 trust, and all of those things were all issues that were raised and dealt with by Judge Vey at the trial court level. With respect to Tank Menace and this issue that there's some competing judgments with respect to whether or not Tank Menace had an interest in the property, it was very clear. Tank Menace's position was, we sold it. So therefore, we don't have to be a party to this litigation anymore because we don't own it anymore.
Is the fundamental question, is a disagreement as to the parties procedurally when, in essence, you lose the motion for summary judgment, right? What type of proof at trial is necessary to be successful? And so your position is that the 56D compliance results in the funneling of the trial to these very specific issues, and your brother argues different, that you still have to prove the entirety.
Yes, and I don't think there's any...
Is that the fundamental difference?
I think so, and
that
I don't think that there's anything in 56D that requires that you have to win on the summary judgment in order to have those facts carry over. This was a perfect case for summary judgment because there were all of these sort of tangential things out there that Judge Vey could narrow, and for the purposes of the trial only needed to address the U.S. Bank being the trustee to make sure that the foreclosure was valid. If there's nothing else, we'll rest on our brief for the remainder of any argument.
Seeing nothing.
Thank you.
Thank you both. Take it under advisement. Our next case is 23P 1504, Department of Children and Families versus Mother and Father. Just want to remind the parties that this case is impounded, so please do not use any names. Mr. Newbill.
Yes, Your Honor. Good morning, Your Honors. May it please the Court, Attorney Lucas Newbill on behalf of the appellant father. The Department of Children and Families, in terminating these parents' parental rights, introduced 106 exhibits dating back to the year 2006. The trial was held in 2022 or 2023. Over 2,000 pages of documents were introduced. I took it upon myself to go through the affidavit alone, which was a mere 8 pages of those 2,000 documents. And I counted 18 identified totem pole hearsay declarants, making totem pole hearsay that was admitted for the truth of the matter in this case. Okay? Extrapolating from that, it's reasonable to think that there are upwards of 50 to 100 totem pole hearsay declarants introduced for the truth of the matter in this case. And the answer to that under Luke is, well, the parents should have called these 100 people. They have an opportunity to rebut these totem pole hearsay statements. Why didn't they locate these declarants from 2006, 2007, 2008, find out their new address, and serve them process and have them appear in court? That's the illusory promise under care and protection of Luke that admitting totem pole hearsay comports with due process, right? But alas, Luke is the law, right? And these parents were forced to confront that reality, and that's the binding authority on this court, right? But what was not addressed in Luke is what happens when some of these totem pole hearsay statements are directly contradicted by other extremely, much more reliable hearsay statements, right? And that's exactly what we had in this case. We had a young child, well, a teenager, who had sworn under oath at a criminal case that her father had not touched her, had not harmed her. The allegation was that he had been violent with her. At the criminal case, under the penalty of perjury, she said that that's not what happened. At the in the juvenile court, the Department of Children and Families was able to overcome that by merely submitting a DCF report that therein contained a social worker, that therein contained a statement from 2 years before that the child had told her that she lied at trial. Okay, judge said, that's reliable, and we don't want to consider what she stated in the criminal trial. The father's attorney there.
Let me interrupt you for a moment. I didn't read the judge to say we don't want to consider what she said at trial. What I read it to be is you got the wrong person. You need independently, as a form of admissible evidence, to bring in this individual, and we'd be happy to hear. And there's no, or some other exception as if there was a witness that was unavailable. Why there would be in rules of evidence the admissibility of that type of statement. So I didn't read it as that's all we're going to look at, just that each side has a burden and has to deal with particular challenges. And so if this is important to you, you know where she lives, you could bring her in, you could have her testify, or if you claim she's unavailable, then there are other it would be an offer that you could make to the judge to try to have the judge consider that. Why am I wrong in that belief?
I don't think you are wrong, Your Honor, and I think that's part of the problem, right? Is that in order to rebut 100 hearsay declarants, a parent has to call in every one of them, and it's really death by 1,000 cuts, right? I'm here before you, and what's the harm in that cut? What's the harm in that cut? But when the department comes with 2,000 pages of documents and 100 hearsay statements, that's when you get where the harm is, right? And why should, in order to rebut a single statement, a parent have to call in a witness and open up that witness to any number of testimony? And if the parent is calling that witness in his or her case in chief, or even on rebuttal, there's a real question as to whether or not the parent's attorney can lead that witness. So then you have an attorney who's fumbling around with open-ended questions with a witness that he or she called in order to rebut a statement that she made or maybe didn't make 2 years before that was stuck in a DCF report. I think a real clear-cut example or a perfect question here is, why is totem pole hearsay in DCF reports more reliable than totem pole hearsay in a police report?
Well, the legislature made that determination, right?
But, Your Honor, I would disagree with that.
Well, there's the statute that covers it, though, right?
The statute covers court investigator reports only.
Yes.
And that does not apply to 51Bs, investigations, family assessments.
But they are official records, though, right?
They are official records, Your Honor. They are official records just like a police report is an official record. But there is no statutory exception that says that hearsay in a DCF report comes in. That's Luke. And it was invented, it was created by Luke. It was not, there's no statutory authority for that exception. Luke
It narrowed the exception.
Sorry, Your Honor?
Luke narrowed the exception.
Your Honor, I vehemently disagree that Luke narrowed the exception. Luke was closely watched by trial court attorneys, which I am in the juvenile court, because it changed the law of the land. And it basically what it did was say to trial court attorneys, oh, there goes the point in motions in limine. We can't, when totem pole hearsay is admissible in 2,000 pages of documents, and the only opportunity you have to rebut that is calling those 100 totem pole hearsay declarants, well, the game is rigged, right? And adoption of George did not make that. And in fact, Adoption, Care and Protection of Luke made that clear. I don't have the pin site on me, but stated that to the extent there was any understanding that adoption of George stood for the proposition that hearsay within DCF documents was admissible, was an incorrect reading of adoption of George. That was dicta therein, wherein they were talking about why these are official records, and the statements of persons reporting to an official duty should be admissible.
So prior to, we had 11924, right? Which allowed hearsay in court investigative reports. And so while perhaps you and your cohorts viewed Luke as some sort of creation of a new hearsay exception, I'm sure we'll hear from counsel for DCF that says, no, we viewed it as a narrowing, right? And a limiting, that we could only introduce that with the second level hearsay if the person, if it's factual and the person is identifiable, to give you an opportunity then to, if it's important, to bring that person in, to put people on a fair playing level. So while it happens all the time, you know, one side thinks this is great and one side thinks it's terrible, or both sides thinks it's something, the fact of the matter is at the time of trial, we had 119 and we had Luke. And you didn't call the person that was available.
Your Honor, just because...
So how was due process violated here when all that had to happen was a permissible way for that evidence to be introduced?
So let me just back up and answer the first question. So Section 24 applies only to court investigator reports, and that makes perfect sense because that's a person who's appointed by the court, who's not a party to the case, and statutorily the legislature said this person's doing an investigation on the case, is going to report to the judge after speaking to all of the involved parties and witnesses, the therapists, everyone involved with this family, right? And the judge needs to be able to take that and make it part of the record because you can't be chasing all of that. That makes perfect sense when you have the person compiling the report not a party to the case. When you have the party to the case preparing the report, it makes no sense, and it's not.
We're going to need you to
Section
answer
24.
the second part of the question quickly because you're out of time.
Okay. Sorry, Your Honor.
Why didn't you call the witness?
Yes, he shouldn't have to call the witness, open up that witness to any number of questions in order to rebut something that when he has reliable hearsay and to counter what's unreliable hearsay to admit, Your Honor. Thank you.
Thank you. Ms. Altamore.
Good morning, Your Honors. Joan Altamore. May it please the Court, my name is Joan Altamore and I represent the appellant mother in this case. A finding of unfitness must be based on current evidence. Mother argues that there was clear error that the court found that mother failed to meaningfully engage in services offered to her to address the issues that brought her family to the attention of the department. This is a child who was born on February 9th, 2020, was removed by the department on February 11th, 2020, 3 days later. The affidavit for the removal specifically addressed the prior children who had been involved with the department. This child was born 3 days. The department had knowledge that mother was pregnant. They had completed home visits to mother back in, I believe it was October, November, and December, knowing that she was pregnant at each time. At no point in time did they indicate to mother that they would be removing this child from her. They scheduled a home visit. The department scheduled a home visit to mother for February 11th, walked into her house, saw that she had a child in her arms, there was adequate supplies for this child, And then the department held a consultation and 3 hours later removed the child from mother, and the child never went back to mother.
But we're focusing on the judicial finding of permanent unfitness, not back when the department scooped up and picked up baby, right?
Correct,
And
Your
so
Honor.
that day has passed, correct?
That day has passed, and
Okay,
that
so
could have been
let's focus
addressed.
on why you believe the trial court erred in making that determination that, given that past conduct can be predictive of future behavior, that her current fitness ability was determined to be unfit, and that would be for the most likely future.
Yes, Your Honor. Thank you. During the course of these proceedings, from the time of 2019, the removal of 2019 until the trial date of June in 2023, there are approximately 6 action plans produced by the department to mother. Those tasks, the judge found that mother was not credible during any of those tasks going from 2020 to 2023, but had found mother to be credible prior to 2020. Moving to address the tasks that were put on her action plan, there are approximately 10 tasks, all which remain the same during that 3.5 to 4 year period. That mother was to meet with the Department of Children and Families on a regular basis, monthly home visits. Mother met with the department. Let's take a break for 2020 when, of course, we had a pandemic, and so home visits, when they did start occurring, a lot of that point in time, they were virtual. But there's no question that mother made her home visits. Second task was for mother to engage in individual therapy. From prior to the removal of the child until approximately 2021, mother had individual therapists. She had approximately 3. When one person moved out of or left the program that she was attending, mother found another individual therapist. At the time of trial, mother did not have an individual therapist, but not because of her, but because her therapist had left her program. That treatment included substance abuse therapy. One of the main focuses was that mother did not have a written relapse plan, but mother had had a substance abuse issue prior to the birth of the child and had discussed, there was testimony from the social worker that they knew that mother had discussed a relapse prevention plan, and mother was not currently using, and acknowledged by the department at trial, by the social worker at trial, that there was no indication that mother had any type of ongoing substance abuse at that point in time. Another task was to complete urine screens. But, and I have forgotten the site completely, dropped my mind, but if the department is not paying for those urine screens, and I think it's approximately 15 years ago that the department, in budget cuts, decided to cut their contract with a urine screener so that if the department cannot pay for it and it is not part of mother's health plan, they cannot use that task against her. But it was used against her in this case. Mother was to engage in the appropriate groups. That's another task. Mother engaged in healthy relationships. Task 7 was demonstrate learned skills during the child's visit. There is more than enough evidence at the trial in the exhibits and in the testimony of mother and the department social workers that mother and this child had a significant bond that was even addressed in the conclusions of law by the judge that this child and the mother had affection and love for each other, and it was shown.
I'm afraid
Because they were granted 2 visits.
you're out of time.
Thank you, Your Honor.
Thank you. Mr. Bruno.
May it please the court. My name is Preston Bruno.
Move the microphone closer up.
May it please the court. My name is Preston Bruno, and I represent the Department of Children and Families in this matter. We'll be using 10 minutes, and my sister for the child will be using 5 minutes. This court should affirm the Bristol Juvenile Court's decision terminating parental rights in this matter because DCF proved on clear and convincing evidence that parents were unfit and that termination was in the child's best interests. The record here adequately supports the trial court's decision to terminate parental rights. The trial court reviewed a number of different factors in assessing unfitness, perhaps primarily and most staggeringly in the record, domestic violence in the family. There was over a decade of domestic violence in the family. There was domestic violence between mother and father. There was domestic violence from mother and father to, not to child necessarily, but to their children. And there was domestic violence with prior romantic partners as well. So there's a long history of domestic violence in this family. Additionally, the trial court had before it 2 videos that were instances of domestic violence. One video showed father grabbing mother by the throat in front of 2 of her children, and the other video showed father grabbing child's half-sister by the throat, carrying her from one room to another, smashing her on the ground, and then punching her twice.
Could I interrupt you? We have seen the videos that were submitted, and we've read the reports. Would you speak to the concerns your brother raised with hearsay evidence and the adoption of Luke?
Yes, Your Honor. So with respect to, as an initial matter, I don't think hearsay is necessarily implicated as to the videos themselves. The trial court reviewed them, and it was entitled to review those and interpret them as it saw them. It was the fact finder, so it had discretion to do that. Hearsay doesn't really come into that. Where hearsay comes into play is father's attempted explanation for what happened in the videos, attempting to explain on his part that he was trying to get mother to spit out some certain pills, and in the other video that they were staging a wrestling match. And then they wanted to bring in half-sister's testimony as to the second video, and that would have been the hearsay they wanted to introduce. The issue is that Luke addressed this precise issue. Luke considered, in the context of care and protection and termination proceedings, what the proper standard under due process is for introducing first and second level hearsay in DCF-created documents. And it expressly recognized that there were due process concerns. It expressly recognized that DCF is a party to the case, which is something that father has raised as a potential concern. It really baked in all of father's concerns when it was walking through the case, and it determined that the proper remedy to ensure we have reliable evidence in DCF matters and to ensure that these matters can be properly brought and completed is to have to call the hearsay declarant if you would like to cross-examine them. That's the proper means of assessing reliability that the Supreme Judicial Court has already determined is appropriate. This court does not need to go any further than that. Moving on to father's additional argument about the extent to which there is hearsay in the record, I would just like to point out that I think in the briefs, father only identified 1 or 2 specific instances of hearsay he had an issue with, and those were surrounding trying to introduce half-sister's testimony. If there was additional sort of hearsay evidence that father wished to introduce, he doesn't suggest what that would be beyond those trial transcripts. Additionally, turning to mother's argument, there was substantial evidence, clear and convincing evidence for the trial court to conclude that this unfitness would be ongoing. As adoption of Catherine says, neither the court nor DCF need to await for the inevitable disaster to occur. Here, DCF intervened at an early stage, but it had a long history with this family, and it intervened to protect the child at issue in this case. There are a number of cases cited in our brief, including adoption of Catherine, discuss the extent to which current unfitness can be sort of a prognostication of unfitness going forward. The trial court has a lengthy discussion, in fact, of adoption of Catherine in her decision that I think does a fine job of explaining exactly why the trial court properly considered reasonable efforts in future fitness. Additionally, there was some argument by mother that maybe mother engaged in some activities and the trial court didn't properly sort of find in her favor on those activities. In our brief, we identify exactly the specific instances that mother is talking about, and we walk through exactly where the court credited her with those instances of compliance, the court just weighed the evidence overall, and it found that it was still wanting for mother. It didn't say that she hadn't done anything. It appropriately credited her where she had engaged in action plan and service plan tasks. And unless the court has any further questions, I think DCF would rest on its brief.
Thank you. Ms. Tierney.
Good morning. May it please the court. I am Sheila Tierney, here representing the appellee child. This is a sad case. This is a case where DCF removed my client when she was 2 days old and had only been in the care of her parents for approximately an hour and a half. They removed her and placed her with her pre-adoptive foster home, where she remained through trial. So through the end of trial, she had been with this one pre-adoptive home for approximately 3.5 years. While mother has done fairly well in terms of the supervised visitation with her daughter, the fact of the matter is this case is not about visitation, but about parental fitness. And at the heart of the claims of parental unfitness in this case is the savage domestic violence and abuse that took place in this household. The record is replete with instances of domestic violence and physical abuse that father perpetrated against mother and the children. The two videos, which were actually home security videos that captured father's violence against mother and the children, that mother, during a time when she had split up with the father, disclosed to the police and to DCF. These videos, as my brother indicated, show father in one instance savagely attacking his daughter, and in another instance attacking mother and grabbing her by the throat and hitting her head into the wall. Father alleged that he was doing this to keep mother from swallowing pills, which the trial judge did not credit. There was an additional disclosed instance of significant violence against his daughter when father smashed her head into the refrigerator to the point where there ended up with a pool of blood on the floor, and the child required staples in order to close the wound to her head. Troubling in this case is the fact that while the case was pending for approximately 3 years before trial, father never acknowledged that he had physically abused the children. He never acknowledged domestic violence against his wife. He refused to participate in a batterers program. He acknowledged that he had problems managing his anger. And the only program having to do with violence was a domestic violence program for victims that he took. With respect to mother, mother has never, throughout the history of this case, placed her safety and the safety of the children over her relationship with father. Although mother has, on occasion, separated from father after instances of domestic violence, she has always returned to him. And I would submit to your honors that you can see her commitment to father because in this case involving my client, the child was only 3 days old. Mom was offered an opportunity to visit with the child the day after the child was removed from her care. And instead of visiting with her infant child, mom chose to go to criminal court with father to be with father while he was there for a criminal charge pending against him. In addition, throughout the case, while the case was pending, mom never once chose to protect herself and her children, to separate from permanently from father. This is something that this court, the trial court, properly considered in determining mother's fitness and in determining whether mother's fitness would continue on into the future. I would submit to your honors that history is prologue, and we have a case here where there is substantial, lengthy, years-long evidence of domestic and physical violence by father, who has refused to acknowledge any problem, who has refused to accept any services to address those deficiencies, and we have a mother who cannot place her safety and the safety of her children over her relationship with father. In fact, at trial, she testified that she was committed to this relationship and committed to making her relationship with father work.
Okay, thank you. Thank you all. We'll take this under advisement. We're going to take a short recess.
Court is in session. Please be seated.
The next case is 24P184 LOCKLEAR versus Argenx US Incorporated. Mr. Margolis.
Thank you. May it please the court. The court below based its ruling,
Thank you, AJ.
on a finding that Trevor Layton, Julie Locklear's supervisor, had no role, had no influence upon her dismissal. That was wrong for a number of reasons. First of all, there's substantial evidence that he did influence the decision. Also, and as I think we all agree, I hope, influence, being in a position to influence or making actual influence is sufficient to defeat summary judgment. And indeed, as the court found in Russell v. McKinney Hospital, being in a position to influence a decision can be sufficient to defeat summary judgment. So that having the influence would have been enough for Ms. Locklear to have prevailed below. Mr. Layton's opportunity to influence is clear. He was a supervisor in a small company. I would ask the rhetorical question, would they have fired Julie Locklear if they knew that Trevor Layton was against it? And if the answer to that were to be, well, yes, would the answer be so strong as to require that jurors be instructed that they had to find that? Because that's the standard for summary judgment, that a directed verdict would be required if the case were tried on the evidence before the court on the motion. As I said, his actual position to influence was clear, but so was his influence. He frequently complained about Ms. Locklear to Sarah Mannell, the HR director. That started immediately after she revealed her handicap to him.
Did she ever convey to them that it was an actual disability?
She actually apparently, according to Layton, did that several weeks before she was fired, but she didn't have to. She described what was a handicap. The law does not require that she say, I have a disability, I have a handicap.
Well, I understand that, but it kind of sets the stage or puts in context what's going on. If Layton doesn't know that she believes she's disabled in some manner, would it be tough to draw an inference that he did something to her because of her disability?
Your Honor, I don't believe that he has to phrase it to himself, gee, she's disabled, and I don't like that.
Well, I don't think he liked the quality of her work. I think that's what the record shows.
Was it that, or was it the fact that she had this condition that might have interfered with her work?
But that's not the standard to survive a motion for summary judgment. We look at the burden-shifting paradigm, and assuming that you establish a prima facie case, and assuming that, on the other hand, that there is a legitimate non-discriminatory reason that is proffered, it rests back with you, not of what if and before a jury. It's at a motion for summary judgment. What evidence did you present that could be considered pretextual?
Well, first of all, Your Honor, we have suggested that the improbability of firing someone in Julie Locklear's position, she was in an absolutely essential position to the company at a time when they were driving to license their drug and then put it on the market, and she was the head of the effort to get it paid for. She was
Can I interrupt? I think the case law is different, and tell me if you disagree, but I believe that you actually have to show evidence somehow of pretext, not bad decision and bad business choice by, is it Argenx, if I'm pronouncing it right, or nobody, you know, would make this action. It's evidence of pretext.
Well, Your Honor, I would note that numerous courts have said that the McDonnell-Douglas test is only a method of ordering evidence and is not required. However, accepting your assumption, there is evidence of pretext. One of the things we argued in our briefs, the fact that Sarah Mannell said, if she had asked for more time, I would have given it to her. But they did not give it to
More
her.
time to attend one of the meetings or respond to one of the communications that she refused to do?
When she was going through this crisis, if she'd said, I need more time, which in fact she did.
I'm sorry, more time for what?
Well, more time to deal with the situation. It wasn't, you know, more time for a specific meeting. I mean, it could have been.
Why wouldn't attending the meetings or participating in communications about the issue not have helped deal with the problem?
Because, Your Honor, this was a woman who was at the end of her rope. There's testimony quoted in the briefs, and it's replete. This was a woman who was exhausted. She had been taken from pillar to post. A few days before she was finally dismissed, she sat in a meeting with Trevor Layton and the HR director, and he went on for over an hour in a diatribe about her. Remember, this is a woman who had delivered her major project 5 days early, which he never acknowledged. He continued to grind away at her. Why did he do that? Simply because he thought her work wasn't good? She says, my work was superb. She says, I checked it with people in the company and outside experts, and they all told me that this presentation was perfectly good. So why would we assume that a juror could not find that there was something else at work here? But getting back to that statement by Mannell, I would have given her more time, that's really a very powerful admission, because what it says is there was no reason to fire her when they did. They could have given her a couple of days. They could have given her another week. We don't know how much time, but they didn't have to do it when they did. So why did they do it so fast? The Superior Court judge, remember, this was only a 24-hour period between when she said, I can't meet with this guy, to when they said, you're fired.
So counsel, this hair trigger type firing, which you may characterize it as, there's nothing in the record of any company protocol or manual or policy regarding firing. Is that correct?
That's true, Your Honor.
So there's nothing to compare her firing with any other employees, correct?
No, but I think jurors can use their common sense to say, that's odd. And another thing that's odd is how carefully they kept Trevor Layton's fingerprints off this issue. Keith Woods, the chief operating officer, sent an email to Sarah Mannell in this period of time, in which he said, I'm meeting with Trevor tomorrow. If they didn't have some mandatory reason why they had to fire her that day, why didn't he wait till after he met with Layton? I think that's...
Doesn't that sound, even as you say it out loud, as speculation and conjecture, which is the very thing that doesn't survive a motion for summary judgment about inconsistent or implausibilities or contradictions? It's more than that. And so, in my mind, if I worked for Amazon and my direct supervisor and I weren't seeing eye to eye, and there may be an issue, and I refuse to meet anymore with my direct supervisor, and I say, I want a meeting with Jeff Bezos immediately, and they get Jeff Bezos on the phone, and I say, not today, and I don't answer the phone, and in 24 hours, they terminate me for giving me what I asked for, and then abandoning, in essence, I don't see how that can then be crafted into my supervisor somehow had discriminatory animus toward me.
Given Leighton's hostility toward Ms. LOCKLEAR, beginning at the moment in the very meeting where she reveals her condition. And I would note that they made several offers of accommodation to her, so at the very least, a juror could infer that they regarded her as having a handicap. I suggest that a juror could reasonably infer that given the hostility, given the fact that there was no need to fire her when they did, and that they so studiously avoided speaking to Leighton about this. It may well have been they did speak to corporate counsel who said this is okay. I think a juror could conclude reasonably they were trying to keep Leighton's fingerprints off of it because they knew of Leighton's prejudice, and they were concerned about what would happen if his fingerprints were on it. That's what a juror could think, and a reasonable person could think that.
This is your cat's paw argument or pretext argument.
It's
And as Judge Walsh mentioned earlier, on this third stage of McConnell-Douglas, the pretext, I mean, you cite Staub, you cite Adams, Bower is another significant case on pretext. All those cases have a lot more from which a jury or a judge could draw an inference that there is a pretext. Because often there's not a smoking gun, a discriminatory smoking gun. So we know we're allowed to look at the inferential circumstantial evidence. But in the cases cited, in the cases you've cited, the evidence is a lot stronger that there was that discriminatory intent. So you have, when you marshal your evidence, you have, after he learned of her, first she describes a narcolepsy, and then it was hypersomnia?
Hypersomnia.
He told her that couldn't interfere with her ability to finish her work on time, and he restricted her travel. And what else was Leighton responsible for directly?
Well, if you look at his criticism, Ms. LOCKLEAR testified, and her testimony must be taken as true at this stage, that his criticism was off base, that it was not grounded in the facts, it was simply wrong. Now, a jury might agree with that. They might agree with Leighton. But the question is, if they did not, if they looked at this situation and they say, you know, this looks like it's a wink and a nod, they knew Leighton didn't like her, they saw an opportunity to get rid of her and they took it. And they carefully kept Leighton uninvolved because they knew that it would be the death knell if they kept him involved. Would a judge be required to enter a directed verdict on that? I suggest to you that it doesn't come close. I would also note there is sufficient evidence to conclude that Mannell and Woods themselves were biased against Ms. LOCKLEAR. They knew what was going on. They knew the mental state she was in when she said, I won't meet with Trevor Leighton. And if you look at the record, what do? They keep sending her emails saying, you have to meet with Trevor. You have to meet with Trevor. Maybe they could have done that, but one reason for that could be they knew how hostile Leighton was. They knew what her condition was, but that it's her medical condition, and they knew what her mental state was. There is enough there to conclude that whether they were prejudiced against handicap in general, or as I suggested in the brief, perhaps they just felt that she was taking too much of their time, but that emanated from her handicap. And that is enough for the company to be held liable.
Does the hypersomnia have to be a recognized disability to even function as a predicate for discrimination?
No, Your Honor. The statute is clear. It's a factual question. Does it interfere substantially interfere with a major life activity? Here, the evidence is, including Ms. Locklear's affidavit, is sufficient for a jury to find that her condition did. She couldn't stay awake. And the fact that
But it was not narcolepsy.
it's a little different from narcolepsy. I'm not a doctor. I'm not going to get into it. But, you know, she was there, and she kept on going. The defense, if I may finish my answer, I know my time is up, but if I may finish this, the defendant argued at some length, well, she didn't ask for an accommodation, but she didn't need an accommodation. She didn't have to do that to be handicapped.
Okay, thank you.
Thank you.
Mr. Menkes.
Good morning. May it please the court, my name is Michael Menkes, and I represent Argenx. I'd like to start with the fact that I think, as you recognize, there has to be some evidence of pretext. There has to be some evidence that sheds some doubt on the truthfulness of the employer's stated reason for the decision. And here there's not. And what's nice here is it's a pretty clean record, especially as employment discrimination cases go. It's not a he said, she said. Everything, all the facts are in email. There's a story to be told that all you need to go through is the emails and see the story and what transpires. And I know my brother keeps focusing on Mr. Layton's conduct, and while we disagree as to whether there's evidence that Mr. Layton harbored any discriminatory animus against Mrs. Locklear, what I would state is it really doesn't matter in this case. If she was terminated for poor performance, it might be a different story. If there could be a disagreement as to, well, was Mr. Layton's performance criticisms honest criticisms or not, that might be a different case. But that's not what we have here. We have a record that shows over the course of 48 hours, not 24 hours, 48 hours, 2 days, the company made numerous, not just one or two, this is not a quick trigger type of case. This is a situation where they said, please go meet with your manager one-on-one. First she said yes, actually, but then she said, no, I'm not meeting with him. She didn't just say I'm not meeting with him today. She says, I'm not meeting with him in the future either. So did the company fire her there for doing that? No. What they did was Ms. Mantle said, I'll tell you what, you don't have to meet with him one-on-one, come meet with me and him. I'm essentially kind of begging him, please meet with the two of us, and telling him I expect you to meet with the two of us. And then he refused to meet with the two of them and said, I'm not meeting with the two of you, it doesn't matter that you're there, I want a meeting with the COO. And so Ms. Mantle says, well, the CEO's traveling, so I don't know if I could coordinate that meeting, but let me see what I can do. And the CEO, who's now copied on this email chain, because Ms. Locklear copies him on the email chain, says, hey, I'm going to make myself available, let's figure this out. Not only does he agree to meet with her, but he actually says to her, we can find time with Sarah, that's Mantle, to speak tomorrow. This is him speaking to Ms. Locklear. But I do hope you will have the call with Trevor and Sarah first. We must work through these differences together. I am committed to help, and Argenx is committed to HEOR. We need this for the patients. Let's find a way. This is not the message of someone who is saying, let's fire this person. This is someone who's pleading with the employee, hey, I'm on your side. I support you here. I'm going to make myself available. Let's talk about it. They have this meeting, and actually before the meeting, Ms. Mantle says to Ms. Locklear, I expect you to be at this meeting. We're scheduling for 2 o'clock. You need to be there. Mr. Woods has gone out of his way to make himself available while traveling. You need to be there for the meeting. What happens? She doesn't respond. She doesn't show up for the meeting. Not only does she not show up for the meeting, but then right after the meeting, about 13 minutes later, Ms. Mantle writes to her and says, Keith and I were both on the phone for that call that you asked for in your emails last night. You did not respond to the invite after I let you know that you're expected to join the call. This is not acceptable behavior. So again, right there, even at that point, they don't fire her right away. They say, what happened? Why weren't you on this call? That's not acceptable. And she never responds, and that's at 2:13 p.m. And then Ms. Mantle leaves her voicemails, sends her a text, sends her another email, And it's only when it becomes 7:30 at night and she doesn't respond, she hasn't shown up at the meeting, she hasn't shown up at all, that the company says, this is it. You know, we're a real company, we're trying to do things here, we can't have someone who's going to ignore us, who's not going to engage in communications with us. Maybe it was one thing when she wouldn't engage with Leighton, but now she won't engage with you, meaning Ms. Mannell, and this is the COO saying now she won't engage with me, the COO. You know, this is not someone we should have working here, we're kind of too busy for this. So that's the story in a nutshell, and there's no evidence that I could see that sheds light on the company's reason at all. I mean, this is all based on Ms. Locklear's actions. It has nothing to do with Mr. Leighton. At this point, there's a whole series of events that, you know, ends by far any causal connection you could try to tie to Mr. Leighton's conduct towards Ms. Locklear and the ultimate termination decision.
Well, would you agree that the relationship between Leighton and Locklear, that was a bit of an abrupt deterioration there when she essentially on the summary judgment record disclosed her disability. And that's when things really went south. That's when on the record he criticized her work, he restricted her travel, and then Manley and others are aware that she doesn't even want to meet with him. So as a company, that's an issue on a number of levels. And might it be inferential that, well, why don't we just get rid of her? She's a problem to Leighton. She's got some sort of disability. She's not meeting her standards. She won't even meet with him. This is a perfect chance to just cut our ties with her.
So I think there are two parts to that question. I'll take the second one first, because I think it's even more straightforward, is they didn't act, when you read the email exchanges, that's not how they were behaving. If they just said, oh, she won't meet with her supervisor, we need to fire her, you know, then you could say, oh, they wanted to get rid of him. Potentially, you could say they wanted to get rid of her. Oh, look, here's an opportunity. She won't meet with a manager. Let's let her go. But if you look at the email exchanges, you could see, and it's pretty clear in these emails, that it's Ms. Mannell and Mr. Wood saying, please meet with us. I mean, they gave her 5 separate opportunities to meet with them, and that's not even including that last text. And even at the end of it, when they said, we're letting you go because we think you quit your job because we haven't heard from you, did she come back to them and say, oh, wait a second, you got that wrong. I didn't quit. I was actually busy today, and I meant to call you back. She just ignored that, too. Never once did she come back and say, hey, wait, this is a misunderstanding. You have things wrong. She's the one who set this all in motion and let it play out. So if you look at those email exchanges, it's just not the behavior that individuals who want to terminate someone would engage in. They would have had the quick trigger. They would have said, the first chance they got, they would have said, you're fired. Or at least they wouldn't have acted supportive in response and said, hey, we're here to help you. We're here to support you. Just get on the call with us and let's see what we can work out. Ms. Mannell even went so far in one of her first emails when this all started to say, I know you don't want to work for Mr. Leighton at all anymore and you're having issues. She said, we will consider that. I will get the appropriate parties together and we'll consider changing your manager. That was one of the first things Ms. Mannell said. If you look at the first email that Ms. Mannell said when she said that she would not attend that meeting with Mr. Leighton, she says, the resolutions you suggest, among others, will be discussed among the appropriate parties, but in the meantime, the work continues. So this is that first email. This is at the first day. This is before the CEO made himself available. She's saying, well, actually consider changing your manager. So again, these are not the actions or activities of a company that's trying to get rid of someone because they're a problem. It's actually if you look at the behaviors, it's the behaviors, it's kind of words of someone who, as my brother said, this person is critical to the business. There's something important going on here. Let's try to keep her here. Let's try to work through this so we don't have to start over and hire someone new into this important position.
Well, if they're trying that hard, what do you make of your brother is emphasizing her request for more time? I need a little more time. They didn't grant her more time.
Well, she didn't say she wanted more time. She said something along those lines. I will say that she said, I think I need time to consider my options. And again, but in response to that, they said, no, so the response to that was, this is Ms. Mannell, and again, this is now like the 4th time she's tried to arrange calls. She said, listen, you sent emails last night requesting a meeting with Keith, who, as you know, is overseas. We have done our best to accommodate your request. You're expected to attend this meeting. So yeah, so they didn't fire her and say no. They said, okay, but we have this meeting. I got Keith, the COO, who's traveling, to be available to stop in the middle of his day while I was driving at 2 p.m. to have a call with you. So great, you want time to think about your options? Keith is going to be on that call at 2 o'clock, and we expect you on that call at 2 o'clock. And again, as I said, even when she didn't show up for that call, they didn't right away say she's fired. It was like, hey, why weren't you on that call? We were on that call. That's inappropriate.
But if I'm to understand your argument, which seems to be viewing the facts in the light most favorable to your own clients, which is not the standard, your position is that lucky us, because we have the cleanest record here on the issue of pretext, because they provided a non-discriminatory reason. Basically, you didn't show up when the big boss called, you abandoned your job, you quit, we're firing you, whatever, it has nothing to do with discrimination. If I'm to accept that premise, it also comes with it that whatever Leighton did doesn't matter, because A, Leighton wasn't involved, and if you look at this very clean record, it was because she asked for a meeting with the bigwigs, and despite 5 legitimate attempts to talk to her, she refused to talk, therefore, legitimate reason, right? But then I think, well, what if, and isn't the jury entitled to consider, what if Leighton really was, just for a moment, assume Leighton was discriminatory all because she has hypersomnia. And now what was good before is no longer good. We're going to cut this and we're going to make you sweat out the project which wasn't due, and an attempt to make you fail. And there was discriminatory animus on part of Leighton. Is your position, hey, because the corporate people made a call and she rejected the call and didn't respond, that it doesn't matter, that in fact her supervisor had a discriminatory kind of motive or intent in his actions? Are we not to evaluate that at all?
Well, I would say no, and I can go back and evaluate, because I don't think that Leighton acting in a hostile way toward, I don't think the record actually reflects that.
No, I understand, but...
And just to put in perspective, and I promise I'll answer the question, she was only there for 4 months. I mean, so when you say, like, out of nowhere, he got difficult with her, it was the first major project she had, and he had problems with it, and he communicated those in writing, and he communicated what the problems were very specifically. I mean, it was super specific as what the issues were.
But if, generally speaking,
okay,
the issue of pretext goes to the jury as long as they present evidence of pretext, and if there is evidence of it, what you're telling us is don't consider it. It's not relevant, because the real reason is because she didn't show up.
Yes, that is what I'm saying. And the reason why is when you look at the McDonnell-Douglas burden-shifting paradigm, which has been around for over 50 years, that's what it says, how a case should be analyzed in summary judgment. It says, what is the company's stated reason for termination? And is there evidence in the record showing pretext, that it's false, that it's not the real reason? And here, if you look at the record, not only is there no evidence of pretext, but I would say we at Argenx went above and beyond in trying to make sure we meet what's called a burden of persuasion, because they might have the burden of production, which I'd say they failed. But even then, even if they did throw anything out there, then it's still on us, the burden of persuasion. And we need to show that there's not a balanced, equal playing field here when you look at the evidence. So we've tried to go above and beyond to saying, look at the evidence here. Not only is there no evidence of pretext, but all the evidence that exists in this case supports the legitimacy and truthfulness of the company's decision. You know, if you look at the language used, I mean, they gave her every chance to say, sure, I'll meet. You know, fine, I'll meet with the CEO. I asked for this meeting. I mean, she didn't do it. There's nothing in the record that would suggest, I mean, the company couldn't have decided, hey, I have a great idea. I'm thinking this so straight. If we just demand that she meet and keep asking her to meet over and over again, guess what? She's probably going to say no and no and no, and then she's going to ignore our communications, and then we can fire her. Like, it's so improbable, the events that occurred from Ms. LOCKLEAR's standpoint, that no one could have had the foresight to say, oh, this is a great way to get rid of her. Let's give her, numerous opportunities to essentially hang herself here. And, when she takes our bait over and over and over again, then we could terminate her because she has a disability and she's difficult. Here, again, maybe there'd be that argument if they terminate her right away, or they terminate her just because she said, I'm not going to meet with my direct supervisor. Then you could say, oh, wait, that seems a little aggressive. It's a high-level employee. She's going to say, I don't want to meet with my manager. We're going to fire her. But again, if you look at the record, you look at the tone of the emails, you see Ms. Mannell and Mr. Woods, the COO, who are just becoming exasperated with her because the tone of her emails and her unwillingness to meet. She's being insubordinate. She's ignoring their emails. And remember, this is a high-level employee. This is not, a lower-level employee. This employee is someone who's kind of close to the C-suite. She's a director. This is someone the CEO expects, a director of the company, I ask you to speak with me. And that's not even the case here. If you remember, she's the one who asked to talk to the COO. He made himself available. He didn't have to do that. Jeff Bezos doesn't have to say, sure, I will talk to you. But in this case, that happened. They were giving her every benefit of the doubt.
Counsel, Justice Capo presumed that she had a handicap or was perceived as having a handicap, stage 1. What do you say to that?
I would say that the most important evidence on that is that the most recent medical documentation, which was in early February, and this is from her own physician, said LOCKLEAR reported to her doctor that since changing medications, she was sleeping better, no longer needed to nap during the day, and was not falling asleep at meetings. She even mentioned that her boss mentioned she's sharp, her memory is much better, and her cognition has improved. So I would say that at the time of the termination, that she was not significantly restricted in major life activity, and that's why she didn't have a disability, and that's based on her own doctor's note. But I do agree that that is a closer call, and that's why we spent most of the argument and most of the brief dealing with the latter issue being the third stage of the McDonnell-Douglas formula.
Thank you. Thank you both.
Thank you.
We'll take it under advisement. Our next case is 24P234, Wosszczyna and another versus AMERIPRISE Financial Services. Mr. Walls.
Good morning, Your Honors. Eric Walls on behalf of the Woszczynas, and with me is Casey Sack as well. This appeal arises out of a single order dismissing my client's case. The order read entirely in an endorsement that pursuant to paragraph 29, AMERIPRISE Custom Advisory Relationship Agreement, the sole remedy for disagreement between the parties is arbitration. Paragraph 29 of the advisory agreement said a lot more than that arbitration alone was what the parties bargained for. The parties bargained for arbitration before the AAA and pursuant to the rules of the AAA. And when applying or analyzing whether an arbitration agreement or how it should be enforced, the case law is very clear that it's enforced according to its terms. So according to the terms of paragraph 29, the arbitration agreement or the arbitration has to proceed pursuant to the AAA's rules. And as put forth in my brief, I don't want to go through it, you have all read it, but the AAA's rules include Rule 1D, which permits a party, if the AAA declines to administer the case, as happened here.
Yeah, we know they didn't follow the rules, the AAA rules, so it wasn't arbitrable. Does the complaint that was filed in Superior Court only rates allegations involving the select account and not the brokerage account?
Well, so yes, Your Honor. My position is that it alleges violations of a relationship between Mr. DeVilliers and my clients, the Wosczynas, whether it's a misrepresentation, whether it's a failure to follow through on his obligations after they provided instructions to do so. The gravamen of the complaint is there was a financial advisor relationship. And the only contract that covers the financial advisor relationship with my clients is the custom advisory agreement. And if you take a look at the brokerage agreement that was submitted by AMERIPRISE, that concerns the trading of securities. AMERIPRISE's actual effectuation of transactions involving securities.
Well, they say that the Wosczynas didn't open the select account until 2020, so the alleged failure to pay the premiums could only affect the brokerage account.
The allegations in the complaint are that there was a brokerage account and that there were payments made at the time. The complaint does not say that the payments came from the brokerage account. We don't know where the payments actually came from, whether they were the payments were withdrawals from the brokerage account and then used to pay off the policy. But there's not an allegation that the actual payments were made from the brokerage account or by AMERIPRISE at that time. The only payment that we have evidence of is a payment that was directly issued from the select account to Principal, the insurance company, for the premium payment. That check was processed in 2020 after the select account opened. So as for the first several payments that were all made, there aren't allegations in the complaint that, one, those are wrong in any way. So even assuming for a moment that the money that was used to pay those was withdrawn at some point from the brokerage account, it's still not a trade in a security to which the allegations are not that the trades were done incorrectly, that the purchase or the payment of the premium was done incorrectly. That's what the brokerage agreement applies to when AMERIPRISE is performing or providing its brokerage services, whereas the custom advisory relationship, or at that point in time perhaps, no contract governed the relationship between Mr. DeVilliers and my clients.
AMERIPRISE says that the FINRA, the second agreement that involved FINRA, was far broader than the original one, and it covered any controversies with AMERIPRISE. And it is interesting you studiously avoid mentioning FINRA in your complaint or anything. It's not even in your brief.
I don't think that it's.
You don't take on. I'm sorry to interrupt. You don't make an argument until you reply that FINRA doesn't apply. This was the basis of the dispute, was it not?
I'm so sorry?
This was one of the underlying bases of the dispute, is that you should go to FINRA.
The basis for the dispute in the Superior Court.
Right.
Was
it would have been nice if the Superior Court judge had been more explicit in telling you that you have to arbitrate with FINRA rather than you have to arbitrate again, because otherwise it just appears like Groundhog Day and going back to AAA to be shut down again. But why shouldn't you have to go to FINRA?
Well, I think that we shouldn't have to go to FINRA first because the Superior Court judge did say, it didn't say arbitration generally. She said you have to arbitrate back at the AAA pursuant to the custom advisory agreement. So she applied section 29.
She said AAA?
I think she said you have to, I think that the order says pursuant to paragraph 29, AMERIPRISE custom advisory agreement, the sole disagreement, or the sole remedy for disagreement is arbitration.
Yeah, she doesn't say AAA.
But she's applying, the only language she's applying is paragraph 29, which explicitly and unequivocally applies only the AAA rules. And it says explicitly that the sole venue for arbitration is the AAA. So her order would be reading out of section 29 the explicit agreement between the parties. And you can't do that with an arbitration clause. You apply the rules or the letter of the contract. And so by applying paragraph 29, the only place we can go is the AAA. And I would submit still that even from the beginning of this case, the AAA was the right place to bring this dispute. And that Whether,
Can you answer Justice Meade's original question, though, which is, why shouldn't you have to go to FINRA?
so my first response is that I don't believe the allegations in the complaint fall within it. But even assuming that they do, what we end up with here are two contracts which, assuming you're right, both apply to the same dispute. One of them is one that we complied with, and we are still in compliance with, and we were in compliance with when we filed in court, because Rule 1D said explicitly that when the AAA doesn't administer, you can go to court. So we were in compliance there. The other agreement is a different arbitration agreement. So we have if we have two agreements and we're in compliance with both of them, asking us or enforcing one of them, the FINRA agreement, over our compliance with the other one is simply elevating the arbitration clause above the custom advisory agreement.
I wasn't suggesting a choice. I was suggesting that there are two doors, and you only opened one of them, and that one shut on you. So you had another door to enter, and one said AAA and one said FINRA. And so you knocked on AAA, and they slammed you and said, go to the court. And you did, understandably, but you didn't go to the other door, which it appears that you're required to, which is FINRA. And I don't understand the argument that you're not required under that language to go to FINRA. So help me understand why you can say, well, I can just kind of pick one, and as long as I've picked one, and they say, you know, go away, I can go to court. Why aren't you required to at least attempt to go into the FINRA door?
Because the terms of the contract are explicit that what I'm doing is in compliance. It's not as though I breached the AAA contract and didn't go to FINRA. It's that I'm in compliance with both of them. And so the court can't elevate one arbitration agreement over the other. We have two enforceable.
The agreement, but you have a controversy with AMERIPRISE, do you not?
Yes.
And so the second contract says that you have to arbitrate any controversy with AMERIPRISE through FINRA.
That's what one of them says, yes.
So you agree you have a controversy, and the second agreement does say any controversy.
I believe it does say any controversy, but it says any controversy. I believe it says with respect to the brokerage account.
It says with AMERIPRISE.
I believe it does, but I think it still is limited to the account. And we do only have 3 of the 9 pages of the agreement in the record. But my recollection of that agreement is that it is the paragraph 20, the paragraph that precedes the arbitration clause says this pre-dispute agreement applies to disputes involving the account. The word account is capitalized. Nowhere else in the record are we told what the account means. My best guess is that the account means the brokerage account. And then it goes on to say what and where you arbitrate that dispute. But going back to my answer was that the Supreme Court has recently said that you can't elevate an arbitration clause above other contracts. And so if we have 2 equally applicable arbitration clauses, and we're not in violation of one of those 2 because we complied with everything that required us to do, by removing that benefit of the bargain, you're essentially saying, well, the FINRA arbitration clause is stronger than the AAA arbitration clause because I'm in compliance with the AAA one when I'm in court. And so you're picking which of the 2 arbitration clauses to enforce. It would be if I had breached the AAA clause, or my clients had breached it, I would think there's a stronger argument. But in this case, the court would have to, they would have to choose to elevate one of those 2 agreements. And even the U.S. Supreme Court has said you don't elevate this, the preference for arbitration or the policy behind arbitration does not allow a court to elevate one over the other. And so with respect to Section 29, I think the argument is pretty straightforward. The law or the paragraph explicitly required the AAA. We went to the AAA. Like you said, they slammed the door in our face. The rule says you can go to court. We went to court. With respect to, and once we did that, the text of the Federal Arbitration Act and the Massachusetts Uniform Arbitration Act, whichever one we're looking at, says that the only way that a Superior Court judge can compel arbitration after, or can compel arbitration is when there's been a failure or refusal or neglect to arbitrate a claim. And again, with respect to paragraph 29, which is what the court ultimately applied, there was never a refusal. We tried to go to the AAA and we were refused that location. And we've cited numerous federal courts decisions, and I haven't found one yet that actually goes the other way, but the numerous district courts, the 11th Circuit, the 9th Circuit, have found that when in this type of a situation, when a party goes to arbitration and is refused the ability to get there because of the defendant's, because of the company's failure to comply with the procedural rules, then the plaintiff did what they were supposed to do, and there hasn't been a refusal.
Do any of the cases you rely on involve more than one agreement with two different arbitration companies?
I have not found one that involves two different agreements. Multiple of the cases have more than one potential venue. Some of them have New York Stock Exchange, NDA, others say JAMS or AAA. And in the JAMS and AAA one, the fact that they didn't that the plaintiff went to JAMS and the defendant did not comply with JAMS's procedural rules and said you can't arbitrate here, the court found that was that the plaintiff hadn't breached that agreement and the defendant had waived its right, even though there was another venue, the AAA, that the party could have gone to, under the clear terms of the agreement. It was essentially analyzed the same way that we're asking this court to, is that there's a contractual permit. We agreed to go to the AAA. We complied, the plaintiffs complied with that agreement. We bargained for the AAA. Defendant, the AMERIPRISE, is the one that failed to comply, and as a result of that, we didn't get to have the bargain for forum that we expected to.
Would you agree with the analysis that if your complaint is broader than just a select account, then the availability of FINRA is something that must be considered?
What I would say is if the allegations of wrongdoing in the complaint are broader, must it be considered? It can be considered. I believe it's AMERIPRISE's obligation to prove that is the correct and only applicable agreement. I think that in this case, if both of the agreements, the brokerage account and the AAA, the custom advisory agreement, apply, the court can't elevate the FINRA agreement over the AAA agreement. If only the custom advisory agreement applies, then the court can't apply the brokerage agreement. I think the only way that the brokerage agreement is and FINRA is the place that has to be mandated is if we were wrong and that the custom advisory agreement does not apply at all.
You set? Yeah, okay, thank you.
Thank you, Your Honors.
Ms. Carter.
Good morning. My name is Valerie Carter, and I represent the Appellees, the AMERIPRISE Appellees, and the broker, Darrell DeVillier. I think the Honorable Judge Tracy Duncan got it right when she said at the hearing on the motion to dismiss that there were two contracts. One said arbitration with one company, the other said arbitration with another company. It was clear the agreement was for arbitration. That's a direct quote from page 4 of the transcript of the hearing. The arbitration companies referred to by Judge Duncan are FINRA and AAA, and they are on equal footing. One isn't elevated above the other, except that in the brokerage agreement, it clearly and unambiguously says, you agree that all controversies that arise between us, including but not limited to, related to your brokerage account and any service provided by a broker representative, whether arising before or on or after the date of this agreement. So that seems to me that that answers my brother's question, or your question, about whether the brokerage account only related to disputes arising out of the brokerage agreement. It doesn't. It relates to all controversies.
He says paragraph 29 only allows them to go to AAA.
Excuse me?
He says paragraph 29 only allowed them to go to AAA.
That's correct. And my position on that one is, if you look at the transcript of the hearing, Judge Duncan was clearly intending to say that they tried AAA, that didn't work, therefore the other agreement, the FINRA agreement, is the one that you have to.
The word clear always bothers me. If everything was clear, we probably wouldn't be here. Her order is not clear.
Her order, and that's my point. I believe she made a clerical mistake when she said in the margins of the motion to dismiss that paragraph 29 was the agreement that was in effect. I believe she meant paragraph 28. And the reason that I say that is, no, if you look at the transcript, that's what I was arguing for. And it would have made no sense for me to argue, let's go back to AAA.
No, because that's Groundhog Day, right?
Yeah, that's Groundhog Day, exactly right. The real question here is, if you have two arbitration agreements and one covers all controversies, they can't ignore it. They can't write it out of existence. Their client agreed to it. We agreed to it. It's in existence. And
can I ask you this question? Would you agree that Judge Duncan's written decision is incorrect?
I think if I heard you correctly, and I can't hear you very well.
Sorry about that.
Okay.
Would you agree with me that, based upon what I'm hearing from you, that Judge Duncan's written decision on the motion to dismiss is incorrect?
I would agree that she made a clerical error by saying paragraph 29 of the Custom Advisory Agreement was in effect. I believe that what she meant was paragraph 28 of the brokerage agreement is the one that the parties should go to now. It's clear. Sorry, I won't use the word clear.
It's just an appellate peccadillo.
What was interesting about this case is in the complaint, there was no mention by the Wosczynas of the FINRA agreement. They totally ignored it. They did the same thing when they applied to the AAA. They never informed AAA of the other agreement. So when the AAA issued its administrative declination letter and used that language, you can go to court if you want, they didn't have the benefit of the knowledge of the FINRA agreement. Otherwise, I don't think that language would have been in there. But the real point is that there are no cases that have been cited by the appellants that have the facts that are similar to ours, where there are the two arbitration agreements. So the question is whether the FINRA agreement can be flatly ignored, even though it is applicable because it relates to all controversies. The controversy in this particular case didn't relate to an investment advisory service, which is what paragraph 29 of the Custom Advisory Relationship Agreement was restricted to, it related to an insurance policy, and that's in the complaint. It was an insurance policy that wasn't purchased while they were at AMERIPRISE. It predated AMERIPRISE. So therefore, it wasn't an investment advisory service that AMERIPRISE was providing when the appellants said that there was a breach there. So if it wasn't an investment advisory service, then it fell under the 2018 AMERIPRISE and FINRA agreement, the brokerage agreement. So you have the 2018 brokerage agreement and the 2020 investment advisory agreement. So it would have made more sense to go to FINRA as opposed to AAA. But the whole purpose is you can't just ghost the FINRA agreement. It's there. The parties have to...
Did AMERIPRISE, when the AAA proceedings were beginning, before you were kicked out, did AMERIPRISE say we really need to be at FINRA?
Did AMERIPRISE say that last part?
That you had to be at, we should be at FINRA, not AAA.
They didn't give us the opportunity to do that. The AAA declined administratively.
Before you responded.
And they immediately went into federal court. They did not give us the ability or the opportunity to cure, number one, or to even say, let's go to FINRA. We didn't have that choice. They refused to go to FINRA. You heard them say here today, they believe that that AAA was the only arbitration service that they could go to.
I may not have done justice to your argument about timing, about when the select account wasn't open until 2020. So it's the premiums were related to the brokerage account. Can you develop that or explain that better than I have?
Sure. If you take a look at the complaint, they indicate the dates that the payments were made on the insurance policy. And I believe there were 5 payments that were made by check. All of them except one predated the opening of the 2020 CAR agreement, the Custom Advisory Agreement. Therefore, the only account from which those payments could have been made were the brokerage agreement. So factually, there's no dispute on that issue. And where the FINRA agreement says that any disputes that arise before, on, or after relate to the FINRA arbitration. So even the one payment that was made after the 2020 investment advisory agreement was made doesn't really alter the fact that they still had FINRA to resort to for arbitration of their claims.
You also claim that we need to dismiss this appeal for lack of jurisdiction. Can you explain that?
The Smyth case?
Well, I don't know, but you cite a federal code, section 16B2 of Title IX.
Right. So in the midst of this case, after Judge Duncan decided this case, the Supreme Court of the United States issued Smyth v. Sparizzi. And in that case, they dealt with the Federal Arbitration Act. And the basic holding of it was that when there is an enforceable arbitration agreement, and it's valid, that an appellate court has no jurisdiction to hear it.
That was an interlocutory appeal, right?
Correct.
Yeah, so this is not interlocutory.
No. No, but what it interprets the Section 3 of the Federal Arbitration Act, which says that that arbitration shall be the forum. So from that extent, it didn't matter whether it was...
And then AAA told them they weren't going to do it, so they filed a complaint in Superior Court, making their allegations as, fraud and breach of fiduciary duty, whatever. And that got dismissed because the judge said you have to do arbitration. But that dismissal of their complaint is a final order.
Yes.
So it's not interlocutory.
Excuse me?
So it's not interlocutory if it's final.
Yes, it was a final order.
Okay, so we do have jurisdiction.
The reason Smyth was decided is because there is a major split in the circuits throughout the country. And in the First Circuit, that was one of the circuits where you could choose to file a motion to dismiss rather than a motion to stay. So now, as a result of the Supreme Court case, what would happen is that there would be a stay to make sure that the court could enforce its supervisory jurisdiction, that arbitration would occur. So that should be the result in this case.
And I just interrupt for a moment. Assuming we disagree with that analysis, and assuming that we believe we have subject matter jurisdiction, it's de novo review, correct? So we don't, unless you disagree, do we have to determine whether Judge Duncan made a Scribner's error and wrote 29G or whatever it was when she really meant 28? Isn't our review de novo? If, assuming for a moment that we believe we have subject matter jurisdiction.
I hate to say it, but I really couldn't hear the last part of what you said.
Is the standard of review, assuming we have subject matter jurisdiction, de novo?
Yes, I would agree with that.
So does it really matter whether we accept the argument of Scribner's error that Justice Duncan or Judge Duncan really meant 28 when she wrote 29G, if it's de novo on a motion to dismiss?
That's acceptable too. I mean, the real point here, Your Honor, is that the FINRA agreement has to be treated somehow, has to be considered somehow. It can't just be ignored. It can't go away. Even in the case that they cite in their brief about the court appointing a substitute arbitral forum, that was when there was only one arbitral forum that was under consideration. It wasn't like the facts here where there are the two arbitral forums that are in effect.
I have another question on jurisdiction. So what if Judge Duncan ruled in favor of the plaintiffs and said you can go forward with your Superior Court complaint? Would you be able to appeal that?
We would, at that point, especially given the Smyth versus Sparizzi decision at that point, which would have been published, we would have been able to, I think, remove to federal court and move for a stay. But the problem is that neither the complaint to the Superior Court nor the claim in AAA referred to, mentioned, or dealt with the FINRA agreement. So they had no knowledge of it. So if Judge Duncan's whole premise was the parties agreed to arbitration, and she had the knowledge from my motion to dismiss that FINRA was one of the arbitral forums, then her position was that this case has to be arbitrated, not litigated.
Okay.
Thank
We're going to leave it there. Thank you. Thank you both. We're going to take a short break to reconstitute the panel.